Elsewhere, through the example of what we would call a small Twitter storm, I've explored how our choices of what we draw upon in our online creations and the conditions for the release of what we decide to communicate determine the power or impact of our creations, both intended and unintended. This allowed me to demonstrate how the three elements of my suggested digital creation framework interact or work together. In fact, what we saw was that these three elements can be conceptualized as a form of production line. Elements go in and something that is the sum of its parts comes out. The added dimension to the standard production line here is that the third element outlines how the output product functions in context, rather than just sitting on that assembly line. In other words, we have begun to think about what happens once that creation enters society and our interconnected online and offline worlds. Here, I want to explore these elements further by thinking about the all-important legal dimension, the legal responsibilities and consequences that these elements include. In other words, I want to focus more on the legal aspects and associated questions we need to ask ourselves as we choose material to draw upon, no matter what conditions we choose for our creations. I'll keep coming back to this point. The reason I'm focusing on this is to ensure that we can at least manage the legal impact of our creations. As I have explored elsewhere, we cannot always control the impact or reception of our creations, something we have to consider before creating. In other words, my aim here is to remove the possibility of us running into legal problems as a result of not exercising the necessary due diligence, i.e., taking the right actions before we publish our communications online. This is not the space to go into all the ins and outs of copyright law and the minute details of the different conditions under which content is published, licenses, and other legal structures. Instead, my aim is to put forward a simple checklist of 3 points you should consider before using others' content. I'll finish by touching upon why this checklist is so universally important. That is why you should always go through this list as you create, no matter what the context for your creations, at home, school, university, or in the workplace, for example. Let's start with the golden rule. This one you might be expecting. Number 1, the golden rule. Remember, everything has a creator. I have elsewhere underlined that it is important to remember that everything online has a creator or author, but it is worth repeating. Once we access the internet through a device, mobile, tablet, computer, it can feel as if we have wide-ranging, free access to all sorts of content. This content feels faceless and anonymous. The author or creator is not always obvious, nor are the conditions under which the content has been published. This brings me swiftly onto point number 2. Number 2, not all content is created and published equal. Different conditions will apply to different content for different reasons. A common misconception is that just because we can access material freely online, all material is fair game and we can use it as we wish. This is false. In fact, all content released online comes with conditions for use. Sometimes these conditions are relatively limited in order to support the broader digital creating community and contribute in a significant way to the future work of others. This is happily the case with this material I am delivering to you here and now, for example, which is released under a form of Creative Commons license. Many of these more open forms of use tend to require the creator to release their content under the same conditions and also attribute or reference the source of their input materials, as is the case with this material. In other words, what we have is a practice that largely mirrors the offline practice in academic research, whereby we document sources and signal to the reader which parts of our work are original, i.e. that we alone have created, and which parts are drawn from or build upon other people's work. The reason conditions apply is to protect fair use. These conditions often also look to protect the intellectual property bound up in creations. When stricter conditions are placed on content, this is often for commercial reasons. Online creations can be an important source of income for individuals and businesses. For example, in some cases, digital creations are offered to the community on a license basis. This means that we are offered the opportunity to buy the right to use a specific piece of content for a specific use. A really great image in a blog post, or a piece of music in a YouTube video, for example. Very strict conditions can be placed on content, text, image, audio, video, etc., to protect brand identity. In this instance, our use, either directly or indirectly, using content as a basis, for example, might be strictly out of bounds. Here, I am making a nod to the many trademark infringement cases that regularly hit international headlines. Take this dog daycare facility in Illinois in the US, for example, Starbucks. Starbucks was forced by the coffee chain Starbucks to change its name, logo, and website. To take another example, we can point to the Canadian website designer Mike Rowe, who registered the domain name www.mikerowesoft.com. Ring any bells? Certainly the technology behemoth, Microsoft, wasn't too pleased. There are therefore all sorts of conditions placed on content for a range of reasons. The key takeaway point here is that there are always restrictions relating to responsible and fair use, even if these are not always super clear-cut. Which brings me on to point number 3. Number 3, we have a responsibility legally and ultimately as netizens to check and triple check what conditions have been placed on the content we want to use. Yes, there are lots of sites which illegally offer you content that we should otherwise pay for. This sort of unfair activity isn't anything new in our societies, but certainly has become a bigger problem with the advance of technology. Some argue that you'll get away with it and won't get found out. Maybe so. However, not only is this dishonest, but it goes against what it means to be netizens. Think about what this would look like in the physical world. We wouldn't take something from someone without paying or asking. The same goes here. Others argue that if what you are creating is just for personal reasons, we don't have to dig too deeply on the content we draw upon. Here, I would again put forward the parallel example in our physical world. We wouldn't take something from someone without paying or asking. The same goes here. Others, again, might argue that they use content believing it was available for their use. Here, we touch upon the need to check, double-check and triple-check content conditions. As I will explore elsewhere, you need to do more than a simple Google image search, for example. But there is also another key argument. It is simply good practice to check and record the conditions of content. Who knows when that personal creation might be shared on a social media site and then circulated, for example? We could also put the boot on the other foot. How would you feel if something you had created was shared without your permission, and perhaps without being paid for? And so this brings us to our final point, the importance of going through this checklist. Unfair use of others' material might well bring lawyers knocking at our doors, i.e. we end up having to deal with the legal impact of what we create and the costs and stress involved in this. But above all, if we are to stay true to the founding principles of the online world and truly exercise netizenship, we ought to undertake the right research and preparation. This is why this simple checklist is so important.